Good morning. Today we're talking about how the Supreme Court makes a decision. So, the Supreme Court has the ability to decide which cases it wants to hear. It can deny a claim for appeal or it can accept it. When it decides that it wants to hear an appeal, it issues what is called a writ of certiorari down to the lower court. In this case, it is normally the appeals court or one of the appeals courts in the United States, telling that court to send the records of that trial up to the Supreme Court for review. And in order for the case to then be heard, the Supreme Court follows the rule of four, that if four justices support hearing a case, then the certiorari or the writ is granted. And sometimes before it even gets to the rule of four, it can be denied by a single justice who decides that the case does not meet the warrants of what the Supreme Court wants to hear. Normally that's because there's no compelling issue that the court wants to address at that time. The big thing they look for is they want to find something that's a big enough issue that is important, or they want to resolve things that are been decided in multiple courts that have been ruled on differently. So if the district court or the appeals court in California rules differently than the appeals court in Pennsylvania, the court may want to look at that so that way they can make a single unified decision. They ask for people to file briefs, what are called friend of the court briefs. That's anyone with standing or anyone has an interest in the case can file a petition to give in their opinion on it. So the NRA has filed a lot. The teachers union has filed on behalf of teachers. Anyone who's got a good reason to want to make an argument why the petition should be heard or not heard, or how the court should rule when it gets it, they'll file a friend of the court brief. The Solicitor General, who is the chief attorney of the U.S. government, files the most briefs, and you'll hear a lot about that when the courts deal with things concerning government action. In rendering the decision, the court gives judicial doctrine for district appeals court judges, and the point of this is to make sure that every single case has been adjudicated the same way. We don't really want a court in Louisiana to operate a certain way and a court in Michigan to operate a certain way. We want to make sure that they are doing things all in the same way, and that creates a much fairer system for us. Judicial doctrine has two different forms, procedural and substantive. Procedural doctrine pretty much says this is the way in which you should do your work. And it tells the lower courts, as well as the Supreme Court, or all the federal courts, I should say, that you have to follow precedent when deciding current cases. And that means if a court or the Supreme Court has ruled that a person must be advised of their rights beforehand, and they also must be given an interpretation of those rights if they don't speak English. That means that every court in the land must do that. So if some court doesn't follow that procedure, it's easy for the Supreme Court or an appellate court to say this court or your court did not follow a procedural doctrine, and thus the case must be thrown out or retried. The second thing is that you must have standing to sue. That means you must be one of the parties that are affected by it. So you can't just sue on the grounds that you don't like the decision they made in a case that doesn't involve you. And such that the recently in Texas, during the COVID-19 shutdown, a person sued Texas on the grounds that Texas was not allowed to deny them the right to get an abortion because Texas said that abortion clinics had to shut down. They're not essential businesses. Well, a woman sued Texas, and the case was thrown out because the woman was not pregnant, nor was she seeking an abortion, and therefore she was not directly affected by the actions of the law. She would have to be pregnant and seek an abortion in order for that to matter. A substantive doctrine says that is the policymaking guidelines that every Supreme Court justice contains. One, it says this is how we voted, and so it'll list out, normally you'll see 5-4. That's been the normal norm lately for the Supreme Court, but it can be unanimous. But it tells them not how they prevail, but it's why the side won. And when reaching those decisions, the court will make a statement. And this is normally called the majority statement or the majority opinion. And that gives the doctrine. This is why something was ruled the way it was ruled. And every case going forward will have to adhere to whatever that majority decision was. Whatever the rationale was is why they did it, and why every future court will have to follow that same thing. But if a person doesn't agree, or a justice doesn't agree, I should say, they write a dissenting opinion. And that explains why they disagreed. And sometimes the judge will say, hey, I think this side should have won, but I don't agree with why you say they should have won. So they'll write a concurring opinion. So you have your majority opinion, your dissenting opinions, and your concurring opinions. But only the majority opinion sets the policy. And that says why every single case in the future must be ruled in a certain way. Sometimes these majority opinions and dissenting opinions, and even sometimes the concurring decisions, they disagree in such a way that it creates a ongoing doctrine clash. And if a dissenting opinion occurs and is pretty well thought out, in the future, lawyers and justices will use that dissenting opinion as a means to reverse a majority decision by bringing a new case to the Supreme Court. When judges stick close to the Constitution and they say to the people or to themselves, I will not rule on any way that's outside what the letters on the page says, that says they're using judicial restraint. But those who believe that the Constitution should change with society and evolve over time, those are judicial activism. So what's more important in moving society? Well, I don't know. I think restraint's important. We don't want an unelected official who's a Supreme Court justice changing our society in a way that they see fit. That should be up to the people and the people they elect. But sometimes activism has its place when things are not changing fast enough or things are not being done, and the courts can make a ruling to change those things. So that, in a nutshell, is how the Supreme Court makes decisions. Have a good day. Happy Wednesday.